Welcome to the Louisville Probate Law Podcast with attorney Scott Scheynost. He'll provide helpful information about wills, power of attorney documents, and other issues related to probate law in Kentucky. These tips and easy-to-understand conversations can save you time, money, and stress related to a topic each of us will eventually have to face. Let's join Scott for today's episode. Friends, welcome back. We are here with Scott Scheynost, and today on this episode, we're going to talk about what happens when you get appointed an executor to somebody's estate. Scott, welcome back to the studio, guy. Good to see you.
Good to see you, Jim.
Absolutely. So this is kind of an interesting topic because it's something that people don't really think about. They may not have even heard, of the term executor or executrix if it's a female.
It's a female, yes.
And the big issue is now I don't know what I'm supposed to do. So let's step into this. And I know we're gonna talk a little bit about what an executor and executrix is, and then we're gonna give them 5 really solid tips. I mean, you've done this for many years. You've helped out a lot as an attorney, and I think anybody that's sitting in that boat right now ought to pay attention to this. And if you know somebody who is dealing with an estate, maybe they've been appointed as an executor or an executrix, by all means, share this episode with them because it may be a little bit bigger job than they realize.
Well, yeah, I talk about this a couple times a week. First of all, we just want to make sure we understand the terms. If you have a will and you die, the person that's in charge of your estate is the executor if it's a male, executrix if it's a female. If you don't have a will and you die, the court will normally appoint an administrator for a male and administratrix for a female, and they all basically have the same job. The job is basically to be the captain of the ship for the estate. They're in charge. They're the CEO of the business. The estate is the business. When I'm doing a will for a person and they ask me who should I appoint as executor, I've got 5 kids. I said, pick out the one you don't like because they're going to do all the work and everybody is probably going to be upset with them at some time. So the one you don't like is probably the one that's going to get all the onus of this. And let's name them as executor. But in all seriousness, it's a business,
right?
Okay. The captain of the ship, you don't want to have somebody that, is going to slack off or, maybe not handle things properly. You want somebody that can handle things in a business-like manner. If you've got a friend, a child that's got some business acumen, if they've run a corporation, a business, if they've been an accountant, if they've been an attorney that's done some probate work, and not all attorneys do probate work, that would be somebody that would be a good executor. And then the next question I get is, well, I got 3 kids. I don't want to make any of them mad at me. Can I name all 3 of them as an executor? Well, you can, and that's a bad idea. Mainly because now you got 3 captains of the ship, and let's say that they all want to do something different and nothing happens. So I think it's always a better idea when you're starting off just to name one person to be the captain of the ship, because you only want one person to make the decisions, to be the leader, to decide what to do. And if you don't have that one person, everything's going to flounder just a little bit.
Well, and I think that's an interesting take because a lot of people think it has to be one of the children. It actually doesn't. I mean, you did my will, you did all my estate set up. However, my financial advisor, who's a very close personal friend, is actually my executor. And that way I can kind of keep my kids out of having to make those decisions. And they know this guy, they trust this guy. And so I've kind of got a neutral party to be able to be my captain in that regard.
Everybody's a little bit different, and you probably have a little bit more business stuff going on than somebody else that might, just be a homemaker. So everybody's situation is just a little bit different. And the more complicated your estate, the more things you have in it, the more you want the person that is in charge of it to be able to take care of stuff. And, for some big estates, they name trusts and banks to take care of things. And, you may have a business that has 400 employees. Well, you need somebody to take care of all this stuff for you. But again, this person's in charge. You want them to be able to make some good decisions. You want them to have the respect of everybody. You want them to be able to do certain things just like the CEO of a business. And that's really what's going on here. The administrator, the executor is the CEO of the business. The estate's the business. The estate will have to get a social security number. It's actually a employee identification number to open up bank accounts. The executor will deal with going to court and be appointed, dealing with the attorney, dealing with the bank, dealing with the other heirs.
The executor is actually going to hire the attorney who's going to walk you through this.
Yeah. Now, what's also important to know as the executor, if you're being appointed, is you're entitled to a fee. And in Kentucky, that can be 5% of the personal property of the estates, which could be a lot, could be a little bit. If there's not a whole lot in the estate as far as personal property and you have to do a lot of work, you might be able to petition the court to get some additional money. But that's also important to know. The executor can be paid for their work, and that would be something that would be taxable as income. Some people want to take their share of the estate, which is not taxable as income. There are a whole lot of taxes involved in inheritance. For most people, they don't really kick in if you're a close relative or if the estate's got less than a couple $1 million. So some people will waive their right to be paid so they don't have to pay taxes on it, and they'll just receive their share as part of the inheritance. But the executor can be paid. The executor can be reimbursed for expenses. The executor is in charge of making business decisions for the estate.
Well, and I think one of the important things that you and I have discussed, by the way, friends, if you're listening to this, go back and check out episode 3 of the podcast, because we did talk about how to start a probate claim. So there's going to be some other additional information that you may find helpful. And I'll put a link to episode 3 right there in the show notes. But if you go back to the website, you'll be able to find all those episodes, but I'll make it easy for you in the show notes. Scott, one thing you and I have talked about over the years is the fact that the executor has a fiduciary responsibility, and actually they can be held responsible for malfeasance. Do you want to kind of crack open that nut a little bit?
Right. The fiduciary duty is a little bit more than just a duty to take care of things. A fiduciary duty means you have to take care of things. You can't treat heirs, you can't benefit one heir over the others. For instance, you can't give somebody's inheritance to them before you give it to other people. You can't sell a house for less than it's worth to one of the heirs because you like them and you don't like the other heirs. You have to handle everything in an even manner for the estate. This fiduciary duty is almost like a solemn oath you take with the court. You're basically guaranteeing you're going to do things properly. When you do that, if you violate this fiduciary duty, then the court can remove you and appoint somebody else. So this fiduciary duty is more than just taking care of your brothers and sisters. It's making sure that everything's taken care of properly, professionally, and if you can't do that, then somebody else needs to step in and take your place. So that is something that runs through all your work as executor. You can't give preference to folks. You have to do certain things within certain times. You have a duty to take care of this. It's not just something that you want to do. You have to do it once you assume this responsibility.
It's a big responsibility.
Yeah,
and it really is.
And if you don't want to assume that responsibility, you do not have to be appointed executor. You can waive that right and let somebody else be. But if you assume that duty, then you've got to step up and do it correctly.
Well, we told everybody we're going to give them 5 tips of how to be a perfect executor here. We kind of talked about the first one. It is treat it like a business, run it like a business. I mean, and that's being responsive to a lot of different things. But number 2, that it's a good segue, is to be prompt in your communication.
Right. To me and to everybody else involved in it, I have several states right now where I'm waiting for people to get back with me. It's slowing everything down. It makes the heirs mad because their property's not distributed in time. Sometimes we run into problems with the court not getting stuff filed properly because some people don't return it to me in time. The court likes everything to be done promptly. They don't get happy. The judge doesn't get happy if you're late in filing inventories or anything else that might be required settlements. So you have to be prompt. It's just like a business. If you don't turn your time card in on time, you're not going to get paid. And the estate's no different. If you're going to assume this responsibility, you need to take care of business in a timely manner. You need to be organized too. That's probably the third thing. If you can
Number 3.
Yeah, if you can get your stuff together as far as being an executor, if you have titles of cars and deeds and you have the statements from the banks and you can bring all that stuff into my office, number 1, it makes it a lot easier, which means it's faster to get things done as far as filing documents. And then number 2, it's cheaper because we don't have to go back and redo it. But just like any business, you've probably gone into a mom and pop store. If they can't find something, you may not go back there. If it takes you 30 minutes to find the Pepsi, I'm going to go down the street where I can get it in 2 minutes. So same thing with the estate. If you can be organized, if you can respond to things promptly, if you can give us stuff, it goes smoother, it goes faster, and it goes a lot cheaper.
Well, it's funny because a lot of people might mistakenly assume, well, the attorney handles all that. And really, a lot of times, that's not the case, is it?
Every attorney is a little bit different in how they handle it. Some attorneys do all that work themselves, and they also bill for that work. My view on it is a little bit different. I jump in when you need me. There's certain things that we do. We file a petition. We get everything set up. Most everything else, though, once we get the estate going, I stand back and I wait for you to tell me if you need my help. Some attorneys take control of the checkbook. Some attorneys do everything. But then again, you're paying them hourly to do all that work. For most of the states I handle, most of the work can be done by the executor. They can take care of things. Most of it's a lot of personal property too. I don't want to get involved in all the little knickknacks your parents may have owned. So, most of this is more appropriate for an executor to do anyhow. But some attorneys do all the work. Again, you're paying for what you get. If you come and ask me to do that, we will help you with that. We'll do that. But again, we're going to charge you for it. And it doesn't make a whole lot of sense for me to go down and pick up the mail when you can do that yourself. Or I have to have one of my assistants or somebody else pick it up when we're billing you for it.
I mean, but obviously you'll game plan it with the executor. You'll
Right.
lay out, okay, here's the
Right.
process. Here's what we're going
Right.
to do. Why don't you take this and try to get it back to me by this date?
Right.
Yeah.
Yeah, a little bit like seeing the doctor. If you need to have surgery, you're going to go see a doctor. If you need to take a medicine once a day and you've got the medicine and you can do it yourself, why bother the doctor to do it and go to his office to get it done? So, the more stuff you can do on your own as executor, the more you're going to save the estate money. At the same time, there's going to be certain things the executor may not be able to do. Let's say that you're the executor, you're 75 years old, you have trouble walking. Are you going to be able to mow the grass? Probably not. But you can hire somebody to do that. That's an estate expense. That's a decision from the executor. One of the heirs says, "Why don't you mow the grass?" Well, why don't you mow it?
Yeah, it's not the executor's responsibility
No,
to
it's
mow the
not.
grass.
No,
Yeah.
no. And executors incur expenses. The executors may have to pay for certain things. They may have to have travel expenses or other things involved in this. And executors, they're entitled to be reimbursed for reasonable expenses too, just like anybody in a business.
But that comes back to the point of being organized. Keep your receipts.
Yes.
Present the receipts. Make
Yes.
sure it's logged properly.
Right.
Because at the end of the day, there's probably going to be a summarization of here's the money that was available and here's where it went.
Yeah. At the end of the estate, you've got to close it.
Yeah.
And there's the easy way we probably talked about before and the hard way.
Yep.
If all the heirs don't agree, then the hard way is to show where all the money came from, where all the money went, and all those expenses have to be itemized. And again, another thing about expenses, just like we said before, you've got a fiduciary duty. If there's a guy that does a good job mowing the grass for $20 a week, you want to hire him, you don't get to pay cousin Bob that you like that needs the help $150 a week to mow the grass. So you've got a fiduciary duty to the estate to handle bills in a reasonable manner, to incur reasonable expenses and keep the costs low, to make sure the heirs get their proper share.
Well, this came up in a previous conversation, is that, okay, let's say, dad's passed away a number of years ago, now mom passes and you've got the home. While this is being probated, and this can take a period of months, you've got to make sure as the executor that the insurance on the home is still in effect and things like that. I mean, there are some very practical responsibilities that you have.
That gets back to the fiduciary duties. One of the things that a fiduciary has to do is make sure the assets are protected. If you've got $500,000, you don't put it in the front lawn on a wheelbarrow. You're going to have to take that in the bank and put it in an account. Same thing with the house. A lot of the states, the major asset of the estate's the house. And there's some things regarding real estate and how that passes. We're going to bypass it right now, but let's just assume the house is a major asset of the estate. In that situation, you got to make sure that asset's protected. We've had 3 or 4 tornadoes come through this part of town in the last 6 months. So you want to make sure you have insurance on the house. Other things can happen to the house too. People can break in and burn it down.
Well, the 67 Chevy sitting out in the garage, you got to
could
make
be.
sure that's insured.
And nobody's driving it,
Nobody's
which is another
stealing it,
story.
driving it, whatever.
Yeah, but that's one of the executor's duty is to make sure assets are protected. Assets that are liquid, like money, needs to be put into an estate checking account that earns interest if possible. Assets that are not liquid, like real estate, needs to be protected with insurance, secured. Make sure somebody else doesn't use it that's not supposed to use it. Assets are a major part of the estate, and the executor's duty is to make sure those are protected until they're distributed to other heirs. So they have to be taken care of. Insurance is a big thing. What I see every now and then is somebody lets cousin Bob drive Aunt Mabel's car, but you're doing a couple things when that happens. Number one, you're letting cousin Bob get an advantage that maybe some of the other heirs don't have. You're basically giving cousin Bob a car. And number two, I don't think that's a really good way to protect that asset, because that car may need to be sold later on. You're going to have less miles. It could get dented. Who knows?
Well, that was my worry, is that sudden, out of nowhere, cousin Bob's in a wreck, and that car, the value of that car was supposed to go to the heirs. Now, that's pretty much messed up.
And sometimes you have you want to have insurance on the car too, but you've got deductibles and other things like that to come into play. And dealing with insurance companies in any matter is always a joy when you're trying to get money from them. So you're avoiding all that stuff if you protect it. And it's hard to tell folks sometimes they can't drive a car. Maybe Cousin Bob's been driving this car for 10 years because Aunt let him. Well, Aunt didn't give him that car in the will. It's not his car anymore. That's the estate. And that goes back to running things like a business. Sometimes the executor's got to be truthful with people and sometimes a little bit stern and protect the assets of the estate. Otherwise, again, he's favoring or she's favoring other people.
Well, and that can end up in a legal action if one of the heirs gets upset about it. I mean, and that's a topic for a different day. Estate litigation and stuff like that. When you've got an heir who says, "Well, I got cheated," or something didn't go the way it should have.
Yeah.
That's a whole different story. But again, as the executor, you got to guard against that. You got to protect the estate.
Yeah, and estates are always real sensitive for the heirs because somebody's passed away. And
Highly emotional.
Exactly. It's and sometimes people are mad someone's passed away and they don't know how to express their anger except for other friends and relatives. And you're there and you get yelled at for no reason at all. But it's just a heightened set of emotions in the estate for a whole bunch of reasons. And you've got to be calm and steady and just administer it as best you can. But you want to avoid as much of those emotional issues as you can.
Well, and I think for me, that was my personal reason for going outside the family to appoint the executor, because I didn't want to create that rift between my kids.
Yeah, and
if
like I
somebody
said
has
before,
bad feelings.
pick out the one you don't like. So.
This is why I want my financial guy.
Yeah, that's right.
Last couple of years, man. But it's all good. It's all good. So as we go down these 5 tips to help you be the perfect executor, the next one is to be open with all the heirs. And there's a couple of different areas where we need to talk about.
Yeah. First of all, I always get the question about the will. I've been doing this for about 30 years. I've never read a will or had a reading of the will. That's Hollywood. I've never even heard anybody in Kentucky doing it. Maybe somebody does. To me, it's an expense that shouldn't be incurred by the estate to pay an attorney to read a will. And any will in Kentucky has to be probated, which means it's an open record. And in Jefferson County, you can actually go to the clerk's website without any kind of a password and look up all the wills that have been probated in Louisville till probably about 80, 85.
Wow.
So, what am I going to do with the will? I always have this question from the executor. Bob wants to see it, well, let Bob see it. It's going to be on the computer and everybody literally all over the world is going to be able to see it here in about 3 weeks. So, just let Bob know you're being honest. Give it to him now. There's nothing to hide. If you think it's going to cause problems, well, it's not going to be any better 6 weeks down the road. Bob's just going to get more fired up. And go ahead and be open about the will. Let everybody have a copy of it. It's all going to be public record anyhow. If there's some issues about it, let's go ahead and start addressing those now. Sometimes I find out that wasn't the will. There's another one floating around.
That's an interesting situation.
And well, let's address that before we go probate one and have to litigate which will needs to be probated. But the question about the will and the reading of the will, again, I've yet to have a reading of the will. I would just be open with all heirs and give them a copy because that's going to be public record anyhow. It may have something in there they don't like, but they're going to find out about that sooner or later. And it's probably a little bit easier to deal with it now than it is 2 or 3 years from now when they think they're going to get something and they don't. So being open about the will, I think, is what you need to do if you're the executor. Also, all the other assets too. When we open up an estate, we have to file an inventory that shows the potential assets of the estate. And again, that's public record too. That's something that somebody can go to the clerk's office and see what's been filed as far as the inventory. And if somebody asks what's in the estate, I would go ahead and give them a copy of the inventory that you're going to file anyhow, because that's public record. They can dig around and find that out. Just be open about that. The other things that are going on with the estate, like what's happening with the car, the bank accounts, I would also be open about that with everybody too, because if you're not open, everybody thinks that you're hiding something.
That's a really good point.
And I hear this from a lot of people is, this guy's stealing money from the estate. I know there's this in there, blah, blah, blah. Whenever I've been involved in that situation, that's not the case. Somebody thinks there's something there, but it's not there. When you dig into it a little bit more, somebody just hasn't seen the inventory. If there's something that's floating around that's disappeared, that might be another issue. That's actually pretty rare. But I think people make assumptions without knowing. And if you're open about stuff, if you give them a copy of the will, if you let them know what's in the estate with the inventory, And you don't have to just give it to them. I mean, I would give it to them if they ask or if you think they need it. You don't have to send it out to all the relatives. But if you're open about stuff and you're giving this information to people, they're going to trust you more too. And you're going to have less problems down the road with them trying to determine if you're not taking care of things properly. So if you're open about stuff at the beginning, people are going to trust you more. You're going to find out it's going to be easier to deal with them. Things are going to go smoother. At some point when you're trying to close the estate, you may want to have all the heirs sign a document for what's called an informal settlement. And that means basically that they sign a document saying that the executor handled things properly. If you can get all the heirs to sign that document, we essentially give that to the court, and the court says, well, all the heirs are happy, so we're happy, and they close the estate down, and it makes it a lot simpler, easier, and cheaper for the estate. If you can't do that, then we have to file a formal inventory, which is a listing of all the assets and all the disbursements, and that costs more money. It's basically a big accounting problem, almost like creating a tax form. It costs more money from an attorney standpoint. We have to file that with the court. There's a filing fee involved with that. The court has a backlog about going over those. It can take several months to get that settlement approved, depending on what county you're in. And then everybody's wondering why the estate's still open. You're wanting to close it, and we're basically waiting on the clerk who's got a stack of 55 settlements in front of them, and you're going to be done 6 months from now.
13th and never.
That's right. And, settling the estates is not the biggest priority for circuit court. People are being charged with murder, and you're trying to throw people in jail for certain reasons. So probate court gets things done, but it's not the top priority in the clerk's office for these kind of things.
I want to come back and ask you about two things, and this is stuff you've previously mentioned here in this episode. When it comes to the bank account, you had mentioned that you've got to open up an account for the estate. That's something the
Correct.
executor does. Do they have to do that at a specific bank? I think, if, again, if the person who died was with Bank A,
Right.
but the executor is with Bank B, does it really matter?
What I recommend is that you go to your bank to do that. They don't have to go to a specific bank unless somehow it's directed in the will, and every now and then you run into a will that names a bank to be the trustee, so you probably want to deal with that bank, but that's actually pretty rare. I found out that if you go to your bank and they know you and you have a good business relationship with them, you're going to have a lot easier time dealing with the estate. I was actually talking to somebody in my office today, that another attorney that's been working as an executor, and he went to the bank where the decedent had their account and just rolled the money over, but he had never done any business with that bank, and they didn't know him, and it's just like somebody walking in off the street. They're going to be a little bit more hesitant to take care of stuff promptly. And if you know the people at the bank, you're going to find out they're going to probably approve stuff sooner. Checks are going to clear faster. They're going to be easier to deal with. I just think it's always a good idea to go to a bank where they know you. Okay, and sometimes you don't want to go to a bank where they know you for different reasons. But if you get along good with your bank, everybody usually has their own personal bank, and you're on good terms with the people of that bank, that's where you probably want to go. Your life will be a little bit easier as executor.
And so basically you're going to transfer the funds out of the
Yeah.
the deceased or the decedent's accounts into this other account.
Yeah, when somebody
the
passes
estate.
away, what happens is if the account's just in their name, the account's going to be frozen by the bank. And then when someone's appointed executor, they're going to get authority through a certificate of qualification to go to that bank and transfer that money into an estate checking account. And from that estate checking account, we will show where all the money came from. You got money transferred from Cousin Bob's account into here. We got money transferred from Cousin Bob's savings account into here. We've cashed in, the CD, all those kind of assets. We've sold assets to the house, to the car. All those assets get deposited into the account. And then we also use that account to pay any expenses. You have to pay for gas. You have to pay the executor's fee. You got to pay the attorney.
The insurance premiums we've talked
Exactly.
about.
All the expenses are paid from that account too. So it makes it easier at the end if you've got to show an accounting to the court where all the money came from and where all the money went. And when you get appointed executor, one of the things we do is we'll have you sign a form so we can get it's called an employee identification number from the IRS. The bank won't open up an account unless you have one of these numbers. It's like a Social Security number. So as executor, you have to fill out one of these forms to get this employee identification number for the estate. And then that's the number that the bank uses. That's also the same number you use if you've got to file taxes for the estate for some reason. And then once that happens, you've got an estate checking account. You deposit your assets in it. You disperse your payments from it. You've got an accounting if you need to have it. And it just makes it a lot easier. And actually, you're required to do this too, to show where all the money came from, where all the money went.
Well, as you were talking about that, we talked about the insurance premiums. It also hit me that, the LG&E bill, the gas and electric bill, you need to keep that intact because,
Yeah.
you don't want, okay, well, nobody's there. I don't need to keep the heat on. Well, here comes winter and suddenly the pipes freeze and burst. And now you've got a big issue, right? And that happens. So out of that account, you've got to be paying these ongoing bills that, you just can't go in and turn off everything. And hopefully your attorney will advise you on kind of what you need to do.
Yeah, and again, that's probably the last thing is talk to your attorney about all this stuff.
Tip number 5, rely on your attorney, right?
Yeah. Unless you've run an estate before, unless you've been an executor, there's just a couple of things that you're just not used to seeing that are not that out of the ordinary for estates, but just stuff has to be done. And, we set you up on how to do this stuff, have the forms filled out, get things taken care of. Another thing, too, is when you have to pay for things and disperse assets, assets just shouldn't sit in the bank account. They should earn interest. If you've got all the debts taken care of, you need to disperse assets to the heirs. Well, the heir may not be able to handle the money, but, the law says the heir's got to get that money. The attorney can walk you through all these things that have to be done. My job, I look at it, is to keep you out of trouble.
Right.
Make sure you follow the rules, you do your fiduciary duties, and we don't do anything we're not supposed to. So that's my main job in an estate. That's most attorneys' job in an estate. I try not to charge unless we have to. Some estates need more attention than others for different reasons. Some are bigger, some are smaller, some of them have problems. But they're all a little bit different. But generally, we're not going to jump into you need us. Most of the stuff that's done in an estate, the executor can do, writing checks, taking care of business around the house, cleaning things up. And you just deal with us when you have the legal issues that pop up. What they need to file with the court. When does this need to be taken care of? How do I close this thing down? That's how we handle things. We aren't there writing checks for everybody. We aren't there cleaning up the house. Again, if we do that kind of stuff, we got to charge you. You don't want me doing it to begin with. Number 2, you don't want me charging for that. So we're there for when you need us, and that's when we jump in. Some people need more help than others. That's just the nature of the game. As much as you need us, we'll help you as much as you need.
And if you have a question, simply ask.
That's right. Again, the executor, if you've never done it before, it can be a little bit intimidating. There's usually a reason why the decedent named somebody as executor. It's not because they don't like him. It's because they actually thought a lot of him. So if you've been named as executor, the decedent thought a lot of you. A lot of people look at it as almost their duty because they've been chosen to do that. And really, there's a little bit of that in there with the decedent, I think's choice. It's something that needs to be done for every estate. Most of the time, we're dealing with family members here. Most estates aren't a problem. There are certain issues that always come up. There's almost, always something that happens with one of the heirs at some time. But most of these issues we can work around and take care of. It's a business. It has to be run by a business, but it's got a lot of emotion to it too. Sometimes it's hard to pull the two apart. But it's a business, first of all, because if it's not run like a business, you get in trouble with the court. And the business part of it has to take precedence over the emotional part. And I think you need to remember probably, number 1, as executor, if you can't separate the two, then you may not be the person to be the executor. But if you feel comfortable running it like a business, if you're willing to do it like a business, it's not overly complicated. Most estates are not that complicated. It can usually be done, in about 6 to 10 months, depending on what's going on with the estate. Most of them take a little bit longer than that for different reasons because the executors are trying to take care of stuff. And, every state's a little bit different, but it's not overwhelming. It can be done. And, at the end of it, I think you probably get more out of it than you would as far as compensation, knowing that you've done a job the decedent wanted you to do.
And you did it with honor and integrity, and that's
correct.
That's what it's really about.
It's actually an honor to be named.
Yeah.
I kid about it, but there's a lot of work to be done. The only problem about being an executor, I think, is that nobody will really appreciate all the work you've done unless they've been an executor themselves.
It makes a lot of sense.
You'll get a lot of criticism, and people wonder why things are taking so long, but there's usually a reason for that.
Yeah.
And, if you can work through that, then everything will be okay.
Outstanding. And Scott, if somebody's been listening to this and wants to get in touch with you, maybe they've been appointed as an executor and executrix, or maybe they need to get a will drafted. You're out off Dixie Highway. You've been out there for a number of years.
That's right. We're out in the southwest part of county. That's our main office. We have other places where we can meet you at too. Our phone number there is 502-937-5287. And you can also go to our website, LouisvilleProbateLaw.com, just like it sounds. Contact information there and send us an email. We'll get that and we'll respond to you too. But happy to talk to you, answer some basic questions. Most people that have not done this before really just need to be pointed in the right direction, and we're happy to do that for you.
Outstanding. Scott, it's always a pleasure to talk with you. And friends, if you've been listening to this, once again, I'm going to ask you, if you're interested in hearing more about probate issues, wills, estate types issues, you can find this episode out on iHeartRadio. You can find it out on Spotify. You can find it on Apple Podcasts, Google Podcasts, all those other places. But the easiest place you can go is to LouisvilleProbateLaw.com. We have a separate page on there for the podcast, and you'll be able to listen to all the back episodes. And be sure to check out the show notes. If we've ever mentioned something like the reference back to a previous episode, I'll put a link right there and make it really, really easy for you. So once again, thank you for your time, and we'll be back in a couple of weeks. Take care. Bye-bye. Thank you for listening to this episode of the Louisville Probate Law Podcast with attorney Scott Scheynost. The content provided is for informational purposes only and does not establish an attorney-client relationship. For additional information, visit LouisvilleProbateLaw.com.